Welcome to Free Thought Matters. I'm Andrew Seidel, the Director of Strategic Response at the Freedom from Religion Foundation, which produces this show.
And I'm Elizabeth Cavell, one of the attorneys here at FFRF. We invite you to join FFRF in our vital work to defend the constitutional separation of church and state and to promote free thought. Ask for more information or a sample of our newspaper, Free Thought Today, at ffrf.org.
Today, we are delighted to be interviewing one of the nation's leading constitutional scholars, Geoffrey R. Stone. Professor Stone is author of the prize-winning Perilous Times, and more recently, the book Sex and the Constitution, Sex, Religion, and Law from America's Origins to the 21st Century.
So we'll be talking with Professor Stone about the Enlightenment roots of our nation, which was founded in an age of reason. And we'll be asking him about the Constitution and contraception, LGBTQ rights, the road to Roe, and the very real threats to reproductive rights that we face today.
Professor Stone, thank you so much for joining us on Free Thought Matters.
Thank you so much for having me. I'm delighted to be here.
Now, you have written that the founders viewed Christianity as sort of this impediment to the pursuit of happiness and to progress. Can you elaborate a little bit on that for our listeners?
Well, the nation was founded at the time of the Enlightenment, and most Enlightenment thinkers were rather skeptical, indeed often hostile, to the traditional views of Christianity. People like Voltaire, for example, were quite critical. And among the American founders, people like Jefferson and Franklin lived in a world in which there was a lot of skepticism about that. And the predominant view among the framers was basically one of deism. They did believe there was a God, but it was a very distant God that created the universe, that did not communicate with humans. And basically they felt that most of the tenets of Christianity and the stories of Christianity were nonsense. And people like Jefferson and Franklin and others tended to take the view that the central premise of belief should be do unto others.
So we're not a Christian nation founded on Christian principles?
No, that concept did not exist at all at the time that the nation was founded. Indeed, at that time, only 10 to 20% of all Americans were affiliated with the church. That notion that America was a Christian nation came later during the Second Great Awakening in the 19th century, when people began arguing that that's who we are, really saying that's who we should be, and the notion of a Christian nation. But for the founders themselves, they would have rejected that proposition entirely. Now, they did, in fairness, they did have a sense that there was a need for people in a democracy in particular to have a certain set of ethical beliefs that would enable them to behave in responsible and thoughtful ways and to look out for the interest of others. But that view is basically founded on this notion of do unto others, and that was something which religion could help to promote, because people did have religion, but they did not believe in any of the tenets of Christianity that got more detailed than that.
So you mentioned the Second Great Awakening as sort of the explosion of religion into political life, especially evangelical sort of Christianity. Mm-hmm. So I was really interested in your book where you quote a source and you kind of talk about how by the end of the 1830s, the Second Great Awakening, in political issues, it was pretty much evangelicals on one side and nearly everyone else on the other side. And that really resonates, I feel like, today with public opinion around so many social issues and political issues. And just take, for example, most people are in favor of safe, legal abortion, yet somehow the political movement in opposition to abortion is so powerful. How do you sort of see that parallel between the Second Awakening and what we're experiencing today?
Well, there are real similarities. I mean, the advent of the moral majority in the late 1970s is very reminiscent of the creation of the Second Great Awakening. And before the moral majority, we did not have an evangelical movement as a political force in the United States the way we do today. It was Jerry Falwell and others who united evangelicals around the country and politicized them and brought them together with Catholics on some issues that is really quite reminiscent of the Second Great Awakening. And during that period, again, there was a strong political movement designed to take over the government both at the state level and at the federal level. And they did in that era begin for the first time to move towards prohibiting obscenity. There were no laws against obscenity, for example, at the time that the Constitution was adopted. But those laws began to come into effect in the 19th century, partly as a result of the Second Great Awakening. There were no laws against contraception at the time that the Constitution was adopted, and those laws began to come into effect during the Second Great Awakening. And there were no laws against abortion at the time that the Constitution was founded, or at least before quickening, before the midway point of pregnancy. And again, it was during the Second Great Awakening that the movement began to create laws against abortion. So all of that began to happen during that Christian movement in the first half of the 19th century.
And in a way, that's kind of, it's almost a betrayal of sort of the founding principles. It moves the country away from it. And you explore that a little bit more in your book.
Yeah, people like Jefferson and Adams were very upset by the advent of the evangelical movement during the Second Great Awakening. I mean, they saw this as threatening the secular principles of the Enlightenment and what they thought the nation was founded on. That they respected the right of people to have their religious beliefs, whatever they were, and to act upon them themselves, but they thought it was critical for them not to have those religious beliefs imposed upon the nation. And the idea of separation of church and state was fundamental to the framers, and they began to see that creep away during the Second Great Awakening.
And that was kind of one of the fascinating parts of your book, too, that I thought was you actually don't just limit it to the American founding. You explore even farther back, all the way to ancient times. And there was a lot that I didn't realize about the general acceptance of abortion and sex, and none of these prohibitions on obscenity, as you mentioned earlier.
Right. No, there were basically no laws against obscenity or abortion in the ancient world of the Greeks or the Romans, and sexual freedom was pretty robust in those days, and that remained the case for the most part until well into the Middle Ages. And although there were conclusions about the and assertions about the appropriate behavior with respect to sexuality, they didn't touch on things like obscenity or contraception or abortion until much later. The church began talking about those things, but it didn't adopt secular laws until the 19th century.
Well, I guess my question would be then, is it fair to say that Christianity is really the problem here? I mean,
well, whether it's the problem depends upon how you define what a problem is, of course. Mm-hmm. So, for people who believe in Christianity or believe in the values of Christianity, they would say secularism is the problem. Mm-hmm. And that Christianity it does put forth the right set of values. And they would argue that obscenity is corrupting of morality, and it leads people to engage in unethical and immoral behavior, including fornication and adultery and other kinds of sexual behavior that they condemn. What the problem is depends on what you believe society should look like. But from the standpoint of the framers and of the founding fathers of our nation, they would see and did see the Second Great Awakening, and they would see the moral majority and the movement to evangelicalism today as corrupting of the core values of separation of church and state on which the nation was founded.
And something that we fight for every day.
Right.
And you also mentioned, too, you were talking a little bit earlier about the founders basically essentially believing that morality and religion, they weren't the same thing, but that some people needed maybe religion to guide them to ethical beliefs. And now it seems to be that there's this conflation of the two, that religion and morality are the same thing. It's certainly in the evangelical movement, and that's why we're getting some of these laws.
Right. Well, that was also true during the Second Great Awakening, was the notion that the way you define morality is through religion. And again, the framers rejected that completely.
Yeah.
Right. But the difficulty with that is that the particular precepts of the morality of religion tend to be quite distinct from what other people might quite reasonably believe to be morality. So again, if you go back to the framers, they did not have any particular problem with sex as a matter of immorality. And they certainly didn't. They were opposed to rape, obviously, and they were opposed to sex with children. But when it came to adults, they were pretty much the way we were, say, in the 1960s. And sexual materials were readily available. There were no laws against obscenity. Sex was seen as a positive part of human life. And that didn't begin to change in our country until the Second Great Awakening.
And you even wrote that the laws against sodomy were there, but they were rarely enforced at the time.
Right. Except in the context of sex with children or non-consensual sex, which would have been prohibited whether it was same sex or opposite sex. Laws against sodomy were on the books, but basically were not enforced during that era. That's true.
So during the Second Great Awakening, compared to today, we know that religion influenced politics and influenced lawmaking. It seems like today there's an understanding that laws with a religious purpose threaten the Establishment Clause and violate the Establishment Clause. During the Second Great Awakening, do you think religious political forces were open about the religious purpose behind their policy efforts?
Yes, and they were very explicit about it. On the debates on those issues during the time of the Second Great Awakening, I think it was pretty clear that the members of that movement would articulate their views that society has to abide by good moral values as defined by our religious beliefs. And I think that's similar to the debates today about, say, abortion, where the arguments that are made by the evangelicals work on the assumption that there is a human life that is created at the moment of conception, and they believe that is derived from their religious beliefs. But what they now have tried to do is to make arguments that there's evidence, heartbeats and so on, that produces. But fundamentally, we don't have an objective notion of when a human life comes into being. And the way that the evangelicals maintain that is they basically take their own religious view and try to impose it on society.
You mentioned earlier that divide, the sort of between science, I guess, and religion, they typically had it at the quickening when the mother could first feel a child. But before this evangelical movement, abortions then were perfectly fine.
Right. I mean, there was a sense going all the way back to the Greeks that after quickening, abortion became more problematic. Quickening being the moment in which the woman actually feels movement, and that's typically at about 4.5 months. And at that time, beyond that point, there has always been an ambivalence, at least, about whether abortion was appropriate. And in some parts of the time, it was illegal, but rarely enforced, but it was illegal. But before that, it was always illegal. Throughout all of human history, until the late 19th century, abortion before quickening was legal.
We're talking with Professor Geoffrey Stone, a leading constitutional scholar, about sex and the Constitution. When we come back, we'll delve a little bit more into Roe versus Wade.
And then we'll talk some more about the dangers individual liberties are facing today with changes to the U.S. Supreme Court.
Hi, I'm Ron Reagan, an unabashed atheist, and I'm alarmed by the intrusions of religion into our secular government. That's why I'm asking you to support the Freedom from Religion Foundation, the nation's largest and most effective association of atheists and agnostics, working to keep state and church separate, just like our founding fathers intended. Please support the Freedom from Religion Foundation. Ron Reagan, lifelong atheist, not afraid of burning in hell.
My name is Bill, and I'm an out-of-the-closet apatheist, meaning I don't really care what you believe, and I don't really think that you should care what I believe. I was raised in South Dakota in a strict Catholic family. I was an altar boy. I served Mass a lot of Sundays twice. The priest gave us this little card that said, "In case of accident, please call a priest." I don't really like that idea anymore since I left the church about 40 years ago. Now, if you find me alongside the road after an accident, please call an ambulance and an EMT.
This is Free Thought Matters. I'm Elizabeth Cavell, Associate Counsel.
I'm Andrew Seidel, a constitutional attorney here at the Freedom from Religion Foundation.
And we're back with our special guest, constitutional scholar Geoffrey Stone, author of the book Sex and the Constitution, which examines not only the myth that the United States is a Christian nation, but looks at the evolution of fundamental rights to control one's own body in constitutional law.
Now, we're going to talk about the dangers posed by the current Supreme Court, but you're here in Madison, Wisconsin today to talk at the law school, the 150th anniversary of the law school, about the Warren Court in particular. Do you want to tell us a little bit about that?
Well, this is the 50th anniversary of the end of the Warren Court. And a colleague of mine at the University of Chicago Law School and I have written a book about the Warren Court. And the idea of it is basically to remind people of who the Warren Court justices were, why what they did was important, and why what they did was legitimate. And so our sense is that the Warren Court had a principled vision of constitutional meaning that has been lost in the 50 years since then. The Warren Court does not have the reputation that it deserves. For more than half a century, conservative critics have attacked it as lawless. But critics who say that the Warren Court went too far or was too activist should be asked, which precisely of the Warren Court's decisions would you today overturn? Would you say that states should have the power to segregate public schools, to make it a crime to marry someone of a different race, to forbid married couples to use contraception? Would you really reject the principle of one person, one vote? Courts generally can afford to be relatively deferential to the elected branches of government, except in two fundamental situations. One is where a law disadvantages a group that has historically been disadvantaged and whose interests are likely to be either disregarded or even treated with disdain by members of the majority. That is, that's one of the defects of a democracy. People are not perfect, and majorities sometimes will look at groups like African Americans or women or immigrants or people accused of crime or religious minorities in a way that is either hostile or indifferent. And correcting for that is an important part that the judiciary is responsible for. And the second element is in protecting democracy itself. That one of the risks in a democracy is that if a particular political group gets control of all of the branches of the government, whether it be the state government or the federal government or local government for that matter, they will be sorely tempted to manipulate the law so as to assure their own perpetuation in power. And the courts there in particular have to step in and protect against that. And so the book really looks at the Warren Court from that perspective and identifies a series of decisions that represent what they've done. And the basic argument is that this is a fundamental, correct, and principled way of defining the court's responsibilities.
And some of those decisions, I mean, were still, they had such a huge impact. I mean, in the area that we practice, I mean, Engel versus Vitale, Abingdon v. Schempp, Gideon versus Wainwright, the right to counsel. I mean, this court really changed American justice for generations.
Exactly. And Griswold v. Connecticut, contraception. So yeah, there are a whole series of cases in which the court, on racial issues, of course, Brown v. Board of Education. So yeah, I think that the interesting thing about the Warren Court is, although it's been criticized and condemned for 60 years by conservatives, virtually every one of its controversial decisions remains in place and remains central to the current constitutional law.
So 50-year retrospective on the Warren Court, very interesting and timely topic, but you were a clerk at the Supreme Court for Justice Brennan, and that was during a later period, the Burger Court years, when Roe versus Wade was decided. What was that like?
So Roe was obviously it was a fascinating experience to be there, and it was an interesting process of decision for the court itself. When the court addressed the issue of Roe, one of the things that people don't realize today is that it was not seen as ideologically divisive in the way it later came to be.
I didn't realize that till I delved into your book either. I assumed that it had always been this divisive issue, and that when the Supreme Court decided it, there must have been, enormous protests and all this, and not true.
Not the case. In fact, 3 of Richard Nixon's 4 nominees to the court, Blackmun, Powell, and Berger, all joined the majority in Roe v. Wade. And if the 3 of them hadn't voted that way, Roe v. Wade would have come out the other way. So you had these conservative justices appointed by Richard Nixon enabling Roe to happen. And that seems quite surprising to people when they hear it today, but that was not so shocking at the time. The interesting thing to me about how Roe came about is what drove the justices to the conclusions that they reached. And I think several factors led to that. One was the recognition of the cliche that if men could get pregnant, abortion would be legal. Mm-hmm. And at a time when the court was beginning to become attentive to the way the law did not respect the rights of women, and for the first time began invalidating laws that discriminated against women, that was a factor that I think influenced the justices, that they understood that this was a set of laws that would not have been in place if men were the ones getting pregnant. A second factor that was critical is that the world of illegal abortion was secret for most of the history from the late 19th century to the 1970s, during the period in which abortion was illegal. And the reason it was secret was twofold. I mean, first of all, it had come to be seen as shameful for a woman to have an abortion, but even more important, it was illegal. And so women who went through the process of getting illegal abortions could not speak openly about the experiences that they had. And therefore, there was very little recognition on the part of individuals about what that world was like. And it was only in the late 60s, during the beginning of the women's movement, that women were encouraged to speak out. And stories began being told, and the justices learned about what this world was like. And it was a horrible world of knitting needles and crochet hooks and back alley abortions, and women who died and women whose lives were physically destroyed by people who didn't know what they were doing, elevator operators and taxi cab drivers who were performing abortions. And as the justices learned that, they realized that the illegality of the abortion was tragic. It wasn't just a legal matter. It was that you had 1 million women a year going through this experience that was just horrific. And a third factor that I think very much influenced the justices is that they discovered that abortion had been legal throughout all of history. If you had asked Americans in 1973, was abortion ever legal? They would have said, 80% of them would have said, no, of course not. It's never been legal, right? The assumption was that it was always a crime. And that the justices would have said that in 1965, I suppose. But by the time you got to Roe, they began to understand, partly from their own research, that this was not the case. And part of the story I tell in the book, Sex and the Constitution, is something Harry Blackman wrote about in the opinion in Roe. And what it basically showed is that laws against abortion were not innate. They were religious practices. And they were the product of religion being imposed upon the American people with respect to a freedom that had existed throughout all of Western society. And so all those factors came into play and led the justices, I think, to the conclusion. And the other point, as you say, is when Roe was decided, people today would say it must have been, unbelievably divisive in society. But it was not. At the time Roe was decided, 2/3 of the American people approved of the decision. Newspapers across the country, including in the South, basically were approving of it. And it was not regarded as all that controversial.
Well, you mentioned that this was not a lightning rod issue before Roe, the court decided to take up Roe, and not directly after. But eventually, we know that divisiveness and polarization really occurred. I sort of think of Roe as the one moment you can really point to after which the confirmation process for judges on the Supreme Court and just the institution of the Supreme Court really probably shifted to something so much more ideological, partisan, and political. What is your view on that and how Roe changed the institution of the Supreme Court, or whether it did?
Right. Well, that had begun to happen as a result of the Warren Court. And when Richard Nixon was making his appointees, he was paying more attention to ideology than most of his predecessors had in selecting Supreme Court nominees. So Dwight Eisenhower, a Republican, for example, appointed Earl Warren and William Brennan, who turned out to be very liberal, right? And the most conservative member of the Warren Court was Byron White, who was appointed by John Kennedy. So presidents cared about that, but they were not so focused on it. Nixon was the first of the modern presidents to do that before Roe v. Wade. But as you're right, that over time, it's become much more of a focus. And Roe is certainly a major contributing factor there. And Republican presidents have wanted to see the court overrule Roe v. Wade and have chosen justices in the hope and the expectation that they would do that. So, why did that happen? Well, the moral majority came into existence at the very end of the 1970s, and it was partly about abortion, but it was also about the beginning of the women's movement, about the Equal Rights Amendment that had been put forth, about the beginning of the gay rights movement, about the greater proliferation of sexual material. I mean, all of those things came together, the sexual revolution, all of those things came together. It wasn't only about Roe that evangelicals and Catholics found really threatening to their understanding of the nation. So Roe was a piece of it, but by no means was the only part of it.
Now, in the final minute we have left, you've written that we've taken great steps to protect human dignity. Can we part on a happy note? Do you have any happy thoughts to end with?
Well, it depends how you define human dignity. But if you define it the way I do, I think that the current Supreme Court poses a great danger to that. I think that they have a very rigid, religion-influenced view about what's right and what's wrong.
Will they overturn Roe?
I believe that they will overturn Roe. I think probably not immediately. I think they'll do it gradually. But I have no doubt that there are now 5 justices on the Supreme Court who not only would never have agreed to Roe v. Wade, but who believe Roe v. Wade is utterly anathema, and that they will be determined to get rid of it. Yes, I do think that's the case.
Thank you so much, Professor Stone, for your work and for joining us today. And thank you for watching Free Thought Matters.
Because free thought matters.
Hi, I'm Steve Pinker. In my book, Enlightenment Now, I show that the world has become a better place as reason has been overcoming superstition and tribalism. But the values of the Enlightenment are under attack. That's why I'm a proud member of the Freedom from Religion Foundation, the nation's largest association of free thinkers working to keep state and church separate. Please join me in supporting the Freedom from Religion Foundation to ensure that our government is driven not by religion, but by reason.